Honourable members, we will now proceed with the Foreign Judgments Reciprocal Enforcement Bill 2023, Bill number 4 of 2023, published on the 17th of April 2023. Honourable Attorney General and Minister of Legal Affairs.
Thank you very much, sir. Sir, the bill that is before us, Bill number 4 of 2023, Foreign Judgments Reciprocal Enforcement Bill 2023, represents yet another example of the government's stated policy objective of modernizing the statutory landscape and the legal infrastructure of our country. This was a manifesto promise of our government, and since we assumed government in August 2020, our government has been aggressively delivering on this promise. No doubt, a modern body of laws and an efficient, competent, and impartial legal system are sine qua non of a vibrant, thriving, and democratic society. This bill is part of that menu of modern laws that are so necessary for economic development and investment, in particular, foreign investment. Litigation in any part of the world is expensive, protracted, and time-consuming. In the end, every litigant expects the fruits of the litigation not only to be efficacious, but also effectively enforceable as far and as wide as possible. In brief, this bill guarantees exactly that. Simply put, the reciprocal enforcement of foreign judgment refers to the local enforcement of foreign court orders as well as the foreign enforcement of local court orders. In Guyana, as in most jurisdictions, the general principle is that the recognition and enforcement of foreign judgment is governed by domestic law and the principles of comity, reciprocity, and res judicata. Comity and reciprocity are self-explanatory. Res judicata is a Latin phrase literally translated to mean that the issue in question has been decided by a court of competent jurisdiction in accordance with the laws of that jurisdiction. That is to say, the jurisdiction in which the dispute arose. Simply put, it means that the matter has already been litigated and conclusively and effectually determined, and therefore it would be unnecessary, if not wrong, to relitigate it. In consequence, the judgment or order of the court produced by that litigation is enforceable in another jurisdiction on the basis of comity and reciprocity, which are set out in the laws of the enforcing jurisdiction, similar to the bill that is before this House. This bill permits and authorizes judgment and orders emanating from courts of Guyana to be enforced in any jurisdiction to which the bill applies. Likewise, the bill permits and authorizes orders and judgments obtained in any jurisdiction to which the bill relates to be enforced and enforceable in Guyana. The bill applies to some 60-odd countries which are set out in the schedule. It will be noted that the schedule contains every Commonwealth country, including every English-speaking Caribbean territory and other major jurisdictions in the world, including the United States and China. It will also be noted that the list includes almost all of Guyana's important trading partners and investors. The bill repeals and replaces the current statutory regime governing the enforcement and recognition of foreign judgments. Recognition means that the foreign judgment is equal to any other judgment emanating from our courts. Enforcement means that the foreign judgment can be executed in Guyana because it is recognized as equal to any order of court of a court of Guyana. The procedure to be employed to do so would be that which is set out in the bill, coupled with the ordinary rules of procedure for the enforcement of judgment in Guyana. For completeness of the record, that procedure is set out in Part 72 of the Civil Procedure Rules of 2016 of the Supreme Court of Guyana, which bears the caption Reciprocal Enforcement of Foreign Judgments. To appreciate the law concerning the reciprocal enforcement of foreign judgments and its importance, one must first understand the principle of sovereignty and its limiting effect on state power. The principle of sovereignty of a state dictates that a judgment delivered in one country cannot, in the absence of international agreement, have a direct operation in another country. Sovereignty, while protecting the dominion of a state, if strictly adhered to, creates barriers to international trade. It is out of this reasoning that the jurisprudence to enforce foreign judgment was developed. Historically, this area of the law has been regulated by 1. The principle of comity of nations, which permit recognition of foreign proceedings to the extent that such proceedings are determined to be orderly, fair, and not detrimental to another nation's interest. 2. Common law, which allows the judgment creditor to apply for summary judgment simply by producing the foreign judgment as proof of debt owed by the judgment debtor. And 3. Statute law. However, over time, states came to realize that legislation which sets out the statutory procedures offer person more security as it creates certainty and predictability in the law. Through legislation, persons can benefit from coherent, comprehensive, and a predictable legal system. In Guyana, the statutory scheme for the recognition and enforcement of foreign judgments is governed by the Judgment Extension Ordinance of 1922 and the Foreign Judgment Reciprocal Enforcement Act of 1961. The 1922 ordinance provides for judgment obtained in a superior court in the United Kingdom to be registered and enforced in the Supreme Court of British Guyana. It also empowers the governor, now minister, if satisfied that reciprocal provisions have been made by a dominion outside the UK, to pass an order to extend the provisions of the ordinance to that dominion. The 1961 Act provides for securing, on the basis of reciprocity, the enforcement by registration in Guyana, then British Guyana, of judgments in the superior courts of foreign countries. As can be seen from their enactment dates, both laws predate our independence and fall into the category of laws we inherited while under British rule. Particularly, our foreign judgment legal architecture, like the rest of the Commonwealth, is modeled after the Judgment Extension Act 1868 UK and the Foreign Judgment Reciprocal Enforcement Act 1933 United Kingdom. As indicated by the then Attorney General, Sir Fenton Ramsay, when he presented the Foreign Judgments Reciprocal Enforcement Bill in 1961 in the Legislative Council, he stated, "The bill," and I quote, "the bill before this council is indeed a complete reflection, word for word, of the United Kingdom statute," unquote. However, unlike the UK and other jurisdictions such as Singapore, Kenya, Canada, and Australia, which have amended their laws, Guyana law has not been the subject of any legal reform. In fact, our law was only amended once in 1963. At the time of the passage of the Parent Law in 1961, our law was considered somewhat revolutionary. The then Attorney General, during the second reading of the bill in 1961, had remarked that the law was, and I quote again, "a move in the right direction to break down the barriers, political and constitutional barriers that exist between countries, so as to enable successful litigants in one country to achieve satisfaction, even if the defendant leaves the country before paying up and goes to another country," unquote. However, 6 decades later, if only by sheer passage of time, this act has been rendered anachronistic. Considering the increase in fiscal, commercial, and economic activities, the phenomenal rise in litigation both nationally and transnationally, the costs and time consumed by litigation, naturally there has been a marked reluctance to relitigate legal issues in a new jurisdiction. This has resulted in a revamping of laws across the world that would permit the easy recognition and enforcement of judgments obtained in one jurisdiction in another jurisdiction. Consequently, a jurisdiction that is not part of the global framework becomes unattractive to investors. Bearing this in mind, and coupled with the upward trajectory of Guyana and our recognition as the fastest growing economy, this government has decided that now is an opportune time to repeal the current law. In short, the current law does not reflect best practices and does not promote international trade and investment. More importantly, it is a hindrance to persons who have obtained judgment in one jurisdiction but are unable to collect on their judgment in another jurisdiction. Justice demands that disputes should be settled in a timely manner, allowing such persons to collect on their judgments, especially where the defendant assets lie in another jurisdiction. This means that an effective system must be in place for persons to exercise and enforce their rights. This is crucial today. Due to increase in travel and advancement in technology, assets can be quickly transferred across borders, and without adequate law, persons will not be held accountable for their liabilities. A legal review of our present framework reveals that our laws are problematic for a number of reasons, foremost being the laws are limited in their application to only a few countries. Citizens from the majority of countries with which we do business and conduct other relations cannot have their judgments recognized and enforced in Guyana. Under our current statutory regime, only the judgments from the United Kingdom, Trinidad and Tobago, Grenada, St. Lucia, Barbados, Leeward Islands, British Honduras, now Belize, Jamaica, Bermuda, Nigeria, St. Vincent, Bahamas, and New South Wales can be enforced in the courts of Guyana and vice versa. This limitation was not cured by the Foreign Judgment Reciprocal Enforcement Act of 1961. Although Section 3 of the Act empowers the minister by order to extend the Act to all foreign jurisdiction that offers Guyana's reciprocity, there is no evidence that any order by the minister being the Attorney General, has been found. Diligent searches were made at the Attorney General chambers and at the Ministry of Foreign Affairs to find an order that would have extended our current legislation outside of those countries that I have mentioned. No such order can be found. So we have to assume that that narrow list of countries are the only countries to which judgments obtained in Guyana can be enforced and vice versa. Another difficulty with the current legislative scheme is that it does not set out clearly what judgments may be registered and enforced under the Act and which judgments are excluded from the scope of the Act. This grave uncertainty has led to issues with interpretation of the Act as well as enforcing the provisions of the Act. In other words, the effectiveness of the Act has not been established. The current legal regime is also limited as it only allows for the enforcement of money judgments. However, modern legislation has moved away from this antiquated position and has provided for the enforcement of non-monetary judgments. Some of the countries include Canada, Australia, New Zealand, and some of those countries include Canada, Australia, New Zealand, and Kenya. Moreover, the Commonwealth Secretariat, in their model on recognition of foreign judgment, has provided for the enforcement of non-monetary judgments. The Commonwealth Model Law also recognizes the importance of other grounds for jurisdiction. As noted by the Commonwealth Secretariat, the list of grounds for jurisdiction in traditional Commonwealth legislative models is a restrictive one. The model law therefore includes additional grounds identified by reference to the subject matter of the dispute, such as contract, tort, trusts, etc. To draft this bill, the laws of Kenya, Singapore, Australia, and Canada were examined. Additionally, we looked at the Model Recognition and Enforcement of Foreign Judgments Bill prepared by the Commonwealth Secretariat. It is important to note that while the Commonwealth model abandons the system of registering and enforcing judgments based upon the principle of reciprocity, we have retained it. We believe this is important as while states may have agreement on broad legal principles, there may be disparities concerning certain rules or procedure. Accordingly, the requirement for substantial reciprocity would continue to be a useful tool to ensure that foreign judgments that meet the applicable legal criteria are enforced in Guyana. Clause 3 of the bill cures the limitation issue and provides for the extension of the Act to the countries specified in the schedule. And as I said, the schedule is quite vast in the number of countries that are enumerated therein. The schedule to the bill lists all countries in the Commonwealth and also includes non-Commonwealth countries such as China and the United States of America. Where a country is not listed in the schedule, this act shall also apply to that country if Guyana is obligated to recognize and enforce a judgment of that country under an international agreement. The minister is also empowered to extend the act to any country where the minister is satisfied that substantial reciprocity will be given in relation to the enforcement in that country of judgments obtained in the High Court of Guyana. Clause 4 specifies the list of judgments to which the Act applies. As indicated, this is an updated list. Once law, the Act will apply to money judgments and non-monetary judgments, including a judgment given in any court on appeal against these judgments. Further, the Act will apply to a judgment if that judgment requires the judgment debtor to make an interim payment of a sum of money to the judgment creditor. Additionally, an award in arbitration proceedings can be recognized and enforced. There are a number of international agreements in force to which Guyana is a party on the subject of enforcement of arbitral awards. Example, Convention on the Recognition and Enforcement of Foreign Arbitral Awards. In order for foreign judgments to be recognized and enforced in Guyana, it must be final and conclusive. This is the prevailing common law position as stated in the case of Nuvion against Freeman, 1889, 15 appeal cases, page 1. In this case, Lord Herschel stated at page 9 on the question of finality or conclusiveness of foreign judgment, and I quote, "In order to establish that such a judgment has been pronounced, it must be shown that in the court by which it was pronounced, it conclusively, finally, and forever established the existence of the debt of which it is sought to be made conclusive evidence in this country, so as to make it res judicata between the parties," unquote. As noted in clause 4 of the bill, a judgment shall be treated as final and conclusive even if there is an appeal pending against it or the time within which the appeal may be made or leave for appeal requested has not expired. As explained by Lord Watson in the